Okay, excellent. So let's jump in. All right. So welcome everybody. Welcome to our webinar. The great topic of IP, which intersects really closely with branding. So hopefully you will enjoy this nice lunchtime discussion that Ian and I will have. So we'll do a bit of introduction first before we start. Just to point out, we also got Bree here today. So Bree's the Business Development Manager at Progressive Legal. So thanks for being here with us, Bree. I'll let Ian introduce himself first and kind of talk a little bit about his background and what they do at Progressive Legal, and then I'll do a little introduction of myself as well.
Cool. Thanks, Ava. Yeah, so coming up to 20 years now as a lawyer. Starts to get scary when you start talking in decades. But 10 of the last 10 years, set up my own firm, helping small business with all of the front end protection for their business, and we've helped maybe 4,000 plus businesses now that we can count. Across all those sort of corporate structuring, intellectual property protection, commercial agreements, workplace, privacy, basically everything. We've kind of designed the firm around small business and what they need. My background before that and obviously more in the last 10 years as well is dispute resolution but our goal is to kind of keep small business out of court as much as we can. But if they do find themselves in trouble for whatever reason, or that's the first port of call they come to us for, then obviously we can help with them with that as well.
Excellent. Okay, thanks, Ian. So my name is Ava. My background is actually in marketing and law, so a nice combination of both. I've been working in the technology industry as a marketer kind of the past 7 or 8 years. And I've decided to kind of combine the legal and marketing background and establish Legal Galaxy Marketing, which is a kind of a small marketing consultancy firm which addresses that niche of law firm marketing, which I think it's quite a unique and untapped space, especially across Australia and New Zealand. I'm also an academic at university, so I teach at Macquarie Uni and UNSW. Various kind of different subjects around marketing, management, and strategy. And I think it's a really nice way for me to also help students connect that theory that they learn in uni to that kind of practical or industry insights that I can kind of help provide. So hopefully helping them bridge the gap between theory and practice. So that's a little bit about me. Wonderful. Okay, so let's start now. So let's get into our discussion. Okay, so we've got kind of quite a lot to cover today, but the 3 key things that we'll focus on throughout the discussion today. So number 1, to start off with, why is intellectual property important in actually building a brand? And it's not always necessarily about the legal aspects. It's also a really important thing for your brand, which then leads us to how can you then create a effective IP strategy to help you protect your brand and your brand value as a business. And then later we'll delve into some of the key trends or future trends of where is IP going into in the new world, especially around the advancement of technology, and kind of how we can, what are the future trends and what we can do to kind of prepare ourselves for what's coming kind of in the next couple of years. So with that, I'll start off with some statistics, okay? Because obviously numbers don't lie. So to start off our discussion of why it's important to have an IP strategy in place and how it's going to help you with your branding and creating a long-term brand value. So I've just got some stats here, okay, from IP Australia, which can kind of give us a nice overview of that. This specifically focuses on small to medium enterprises as well, the statistics. So the first one, the share of Australian SMEs that own IP rights has doubled from 2% to 4%. And this is a 2021 report. However, this is the stats from 2002 to 2017. So you can see that it is not kind of an overnight thing, but it's protecting your brand. IP helps protect your brand over the longer term. So it should be included as part of your longer term strategy for the not just the growth of your business, but for protecting your brand. So the second stat that I've got here, so SMEs that own IP rights on average are 3.5 times larger than their peers that have no IP IP protection in place, which then leads to the next one. So SMEs with IP protection are 16% more likely to experience high employment growth. So obviously, because you're growing and you have a larger business, then you need to employ more. And finally, SMEs that file for patents, trademarks, and design rights, they're twice more likely to achieve high turnover growth than their peers with no filings. So here's just a little bit of kind of statistics to give us an overview. So
it's good
with
to frame that discussion, with these types of statistics, because we all sort of fundamentally know that that's probably right. But I think, and I hope that there's going to be more statistics coming out about intellectual property and the value of it, so that people can actually understand, really understand the value of this intangible, sometimes intangible, intellectual property that they have in the business, and why it's so important to not just identify it, but also protect it. And realizing the value of it, means you should pay more attention to protecting it.
Yeah, 100%. Yeah. So with that, we'd like to ask, I'll launch a poll, and can you tell us if you do have an IP protection in place for your business or not at this time? We'd like to know.
So here we'd be talking about, have you registered, or have you identified the the areas of intellectual property for your business? Could be your branding, your name, logo, other sort of badges of origin for your business, any copyright that you're creating for the business, ideas and specific know-how, trade secrets, secret source. What are the types of things that you can identify at the moment, as being of value in the business? You could be getting it created by others, could be getting it created by third parties for branding, etc., for advertising, marketing campaigns, look and feel and get up, colors, a graphic designer, web designer, web development, website, social media handles. There's good. We're sort of getting you to start to think about different types of intellectual property that you've got within your organization, as a starting point, and how do you protect that within your organization, and do you have those those things documented in policies and procedures within the business to make sure that they're that staff and contractors or third parties have to assign those with the contractors, assign over the intellectual property, but with employees, making sure that they're very well aware of any intellectual property that they create is owned by the business, through these policies, and what they can and can't do with it. Potentially a trademark sort of a policy, like how they're able to use that, especially if they're in roles in the organization which allow them access to social media, not just as part of their job. These days it's becoming more prevalent that multiple people within an organization will have access to a company's social media handles, whether it's Twitter or Facebook, Instagram, etc. So the ability to play and publish that intellectual property. Do you have contact lists, your client information? That's all intellectual property as well too, that you've got to consider. pricing guides and structures and how to's, all that sort of stuff that, say for instance, someone walked out tomorrow from the business with that information and wanted to start up a rival company, that you'd be very unhappy for that to take place. That's the kind of things you got to be thinking about. You probably got some IP protection or a strategy. Obviously everything can be better, so don't feel bad. I'm sure we ourselves could tweak a few things, but it's just starting the process of thinking about what's the protection measures you've got in place for your business to make sure, one, that that the business owns it, and if it doesn't at the moment own it, what steps do you need to take place to make sure that that's a sign, and the various acts, including the Copyright Act, is very prescriptive in terms of assignment of that intellectual property. It's got to have specific wording, and should be done properly in order to make sure that it's properly not transferred, assigned. It's a different legal term, and whether it continuously is assigned over, there's some good, if you're going to be working with them more comprehensively on an ongoing basis, there's ways to do that in legal documents.
Yeah, that's really great, Ian. And I guess the other thing I wanted to touch on as well is your thoughts as well. What do you think about because I think it's going to become much more trickier now to kind of protect your intellectual property in the digital world as well. So you've got all this sensitive consumer data that you mentioned, which is kind of part of your intellectual property, which is very sensitive. So now that the world's kind of, especially with the emergence of AI and all these legal technologies as well, what is your intake? Like, how do you think, what's the future of kind of being able to protect your IP in the digital world? Or have you seen any cases or anything specific?
Yeah, I think don't forget about AI for now, but I think the greater danger is actually the ability to transfer data almost instantaneously from within organizations, and measures you put in place to make sure that doesn't happen, so as to safeguard the intellectual property of the business. So think about it, someone walked in and stole a whole bunch of client files from an organization and walked out the door, old school, IP theft. Now that's just so much easier. Obviously, it's a lot easier to track that with the sophisticated software in place, like Google and Microsoft, etc., have more, the tracking of all that information now is far more capable. But obviously, that's all keeping up with technologies. We're trying to keep up with technology constantly because it's moving at such a rapid rate. But I think, generally speaking, the greater issues are going to come from either within or from an external sort of hack of that data. And so IP protection can also, it also involve, making sure that there are, you've got long form passwords and everything held in a password protected, safe custody, where, there's some good online tools these days to have password managers, and the protection of those passwords and sharing of those passwords without people seeing that particular password, and having long form passwords for emails with lots and lots of various types of different characters, etc. I mean, we've seen what happens when even just one point of entry within an organization, emails is a good example. One particular person's email can get hacked, and then from that they then get access to a whole bunch of information because everything starts with the email, right? So I think more generally, the sort of, there's only going to be so much you can do to protect. You can obviously take it as far as you can, but just like a car, if you lock your car, you're you're so much less likely for it to be broken into than if you just left it unlocked. Of course, people, can steal cars and break locks, and that doesn't stop them from stealing a car if they really, really, really want to. But at the end of the day, you just want to make it a little bit harder, and so that they move on to someone else who might be an easier target. And I think that's probably you've got two major threats: the external and the internal, and just having to make sure that all of this stuff is done and locked down and in writing and very clear, unambiguous, with staff and contractors. We see, sometimes, a lot of rogue contractors where the relationship falls apart, and then they hold the IP for ransom. The amount of web developers that we've had to advise against, who are withholding the data and website and holding it to ransom until bills are paid, is just really shocking. Obviously, there's lots of great apples in the industry. There's, like any industry, a number of bad apples. And unfortunately, most of those agreements that we see are very one-sided in their favor, and unfortunately, the business hadn't got those documents legally reviewed before they signed off on them, because everything was great and honky-dory at the time. But then ultimately they found out that it was, more, when the relationship turns sour, then, like they say, you only know who someone really is when you break up with them. And then unfortunately, they've left that intellectual property exposed by not having those legal agreements properly reviewed and done well before they've entered into the transaction. Just sort of trusting that they will do the right thing. Unfortunately, that just doesn't happen in sometimes 50% of the cases.
Yeah, that's great that you mentioned that, because I think even from a branding or marketing or brand awareness point of view as well, or even in terms of gaining competitive advantage through your IP strategy, I think monetization as well, and kind of using your IP in terms of franchising or licensing your IP, that's another kind of, I guess it's a benefit of having an IP strategy where you can kind of develop different types of revenue stream as well. So that kind of leads us to the next point of discussion, and kind of some IP strategies to help protect. You've talked a lot about that as well, but maybe some more specific IP strategies to help us protect our brand value. Maybe specifically if you're thinking about franchising your business or licensing your business, and how can you protect it and make sure, like what you said before, you don't have those rights kind of, in a sense, stolen from you?
Yeah, one of the things that you got to remember, as a business is, you can't sell something you don't own. You can't license something you don't own. You don't have the rights to. You can't deal with those bits of property unless you have the legal rights to do so. And you can't enforce a right that you don't have, right? So, and look, at the end of the day, there's really comes down to this. We know that the successful businesses do a number of different things from a legal perspective, right? They have all their IP registered. If they can't register it, take adequate steps to protect it, either through non-disclosure agreements, confidentiality agreements, or deeds of confidentiality, depending on where the consideration is taking place. And there's some tricky things that you need to kind of think about what sort of document you need to have. In Australia, unfortunately, that's just the way it is at the moment. So if there's no consideration taking place, i.e., money or promise of money or working together, etc., you're best off to have a deed instead of an agreement, because an agreement requires that consideration, as you remember from contract law. Just making sure you have these documents in place that are really thorough, and make sure that any client information, anything sensitive to either the business or its clients or its custodians or stakeholders, employees, referral partners, anything that you can kind of consider, like, hey, I'd be really annoyed if this got out. I'd be really annoyed if that list was published. I'd be really annoyed if those details were ever to be made public, and I'm not talking about, horrible stuff here. I'm just talking about, oh, well, I'm sure, for instance, with law firms, obviously the duty of care is even higher, because we deal with so much sensitive legal information. Client data is absolutely paramount, and that's why at the moment the Law Society is quite rightly banging on and on about making sure, from a data and protection perspective, and privacy and security perspective, that law firms really start to ramp that up, and that's what we've had to do as well too, unfortunately, thanks to all the hackers. That's just something for law firms, but for professional services generally, and any other business that has this type of intellectual property that's sensitive, medical, you can understand it's just sort of the same situation. We just need to really think about making sure that that type of data is only those that need to know have access to that data, and it's made very clear that hey, the business is serious about protecting this data, our clients' information, our clients' details, etc. If you're collecting credit card details, if you correct passports, driver licenses, all that sort of stuff, if you're collecting that information, and you can start to see, we're actually starting to see it ourselves, where as a result of these major hacks, etc., that people are starting to become a little reticent to hand over even just these these documents over email. So they're starting to say, oh, we trust that the information, we just got one email quite recently to say, we trust this information is going to be stored and held securely. So even we're starting to see clients question the security measures of businesses now, and I'm sure if you haven't already started to see that, I mean, some people have refused to hand them over, and unfortunately we've had to say, look, the Law Society requires us to identify who our client is. We need to know this information. Unfortunately, it's just the environment at the moment has made it very difficult to convince people to hand that information over just for validation purposes, but there are obviously ways around it. I know I went off on a tangent there. I know I do that often, but I think the main thing is, first you got to, like anything with a problem, you have to realize there's a problem first, right? So you have to identify all the IP, go through and make a list, an inventory of all of the things in your business that you've created, and you'll be really surprised of how much you can create, especially even in a short amount of time. You can create a lot of information that's really valuable, and even you're thinking of a brand name, you've chosen a brand name, you're starting to amass that intellectual property. When you start to do a business plan and start to do a document with an analysis of the competitive landscape, doing your SWOT analysis and doing your avatars and all that sort of stuff, when you go through marketing, that marketing process, you're starting to develop the brand right then and there. And I think that's what a lot of businesses forget. They're creating brand right from the very start, and it's valuable right from the get-go. As soon as you register your web domain, your social media handles, trademarks, you're often racing right from the start. Whereas I think traditionally people have thought, oh, I'm not there yet, or I'll cross that bridge when I come to it, or my accountant hasn't mentioned that yet, so I don't need to do anything about that just right now. But for some businesses that we advise, if their entire value of the business is intellectual property, we're having to discuss with them straight off the bat, setting up a different legal structure to what we would otherwise recommend, purely on the basis that, hey, you've got, your entire business is your intellectual property. You think about those, businesses, everything is their intellectual property, and now they dominate the top 10 businesses in the world, right? Nvidia, Google, Amazon, Facebook, Meta, the Magic 7 in the US. Guess what? They're all IP firms. There's, General Motors. I mean, Tesla is actually an intellectual property firm. They also make cars, and rockets, and other cool stuff. But really, all the the value is in the autonomous driving software and all the other cool stuff. You're basically just driving a computer on wheels. So that's really what we're seeing that intellectual property is now the oil of the 21st century. Like one of the Gettys had said. So, and that's trickling down, and that's rising up from startups, where now, and I think people are starting to wise up that the smart businesses, because like you would lock the office when you leave for a night, or lunch when it's unattended, like that's that you need to start to think about locking this stuff up and working out what protection measures you put in place to either monitor that, or prosecution if someone else comes too close, starts to engage in trademark infringement, starts to look and feel and be too close for comfort. You might get some actual evidence of confusion in the market where someone's sending you correspondence that they've been sent saying, hey, is this you? Are you doing this now? Or, like that's actual evidence of confusion in the market where consumers are being misled, potentially misled and deceived, right?
Yeah, no, 100%.
And I think as we're running out of domain names, we're now we're running out of domain names, we're running out of original names for business. Like it's starting to get even more important as time goes on to make sure that if you can possibly get registration for some of these trademarks, and other assets, whether that's patent, blah 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 blah, blah, etc. If you can get registered protection, my goodness, like the difference that it makes not only to your own sanity as a business owner, but also, we don't know how many times that people have been fended off by having these things. We obviously can't calculate that because it's an unknown, right? But I can guarantee you when I'm giving advice to some businesses and they've said, hey, we registered this, we want to go with this name, but and we've run some checks and realized that there's, we've had to advise them that, look, I don't think it's a good idea because this person, this company's got a registered trademark over those same exact goods and services, and they have to go back to the drawing board and come up with another name. You'd never know about that because it's obviously confidential advice between our clients and us. So we know it exists out there. We also don't know how many times people have gone and looked this themselves and said, they've gone and looked on the register themselves and said, oh damn, there's a trademark for that. Okay, cool, I won't do that. Like the amount of times that this stops disputes from happening in the first place, or stops someone from coming along and engaging in that conduct and taking business away from you. We don't quite know, but we know that we know that the serious businesses do it anyway. Like Nike wouldn't even need trademarks potentially, right? Because they're so big, they would just be able to steamroll anyone anyway. Apple doesn't probably need trademarks because they know that they're so well known in the market. They wouldn't have to, like, proving reputation ain't going to be too hard for Apple, right? But they do it anyway. They do it anyway because they know the power of the registered trademarks. They know how powerful they are. They tried for 10 years continuously to get the App Store registered, Like you think about it, the App Store. Now it's like obviously it's synonymous, but the IP Australia wouldn't let them have it for 10 years. They kept going and going. I think they had 8 bytes at it, or so, which would have cost an absolute fortune to try and keep proving this evidence. You can imagine how big the affidavits were to try and get this thing. They finally got it over the line, but it took them 10 years to get that.
But I think if you think about it as well, Apple and Nike weren't always Apple and Nike from the beginning, right? So they kind of, this is a longer term. So from the beginning, they kind of implemented these IP strategies, and they've started to build that reputation, that trust over a long period of time, as you said as well.
Absolutely.
So I think that's how you can really see the impacts, right? Of building that trust.
But they wouldn't need these trademarks. Why do they keep going for them? Like, why does Red Bull have 274 trademarks on the Australian register alone? Like it's in areas and categories and goods and services which doesn't seem like they provide, but no one's applied to strike them off for non-use because no one's got the guts to.
I think that's a really interesting point. Yeah. And I think just moving on to the next discussion on that, and how people businesses keep on building on creating new IP protection rights. What do you think about, I think maybe in the past it would have just been about protecting your product or your service or your asset. But what do you think about like companies like Netflix, for example, because marketing is like moving way towards personalization as well. And I think that's a really key future trend in the future as well, personalized consumer experiences. So companies like Netflix, for example, they're not just trademarking or having intellectual property in place for the service or the products that they offer. It's also the process of the way they do things. So for example, you think about that personalization algorithm system that you use, they've actually put an IP on that as well. What's your take on that?
Yeah, I think algorithms are going to be, also you see algorithms used for everything now, and bots will follow you around and retarget and market to you for all sorts of stuff. You start looking at websites and then you'll see ads for all sort of different things on different platforms as well, and then ads coming up on this thing, and you're, oh wow, I've only just started using this site, and suddenly there's ads popping up about it. Like that's obviously that's where we're going. And some of these providers are registering registering their trademarks, etc., over specific those specific services as well too, and businesses popping up that's all they do. They help businesses do that. So and just some more just going back to the Nike example that you raised in the notes as well. Like when you now sort of, it's a really good example. I use Nike a lot because obviously it's a marketing company. Not many people know that it's a marketing company. It doesn't actually make any shoes. Like Airbnb doesn't sell any houses. Doesn't own any houses. Uber might own some cars, but a very small number that they lease to people. There's all these like really big companies that just don't. It's so funny that they, don't own any warehouses or don't own any, bricks and mortar. They're just really marketing companies, or they're just platforms that introduce people. Like Airtasker is a good example. They're just connecting people in this new sort of gig economy. But yeah, now the swoosh is just synonymous. They used to use the Nike with the swoosh underneath it. Now they're just at one stage they just abandoned. They just decided, we're just going to use a swoosh, because now it's just you could use them interchangeably now, right? It's just a swoosh or Just Do It or Nike. They're almost, I would say, they've almost got the same value in each of those different, of the logo, this tagline, the slap line, and the brand name. So they've done a really great job, obviously. And we use the big examples because obviously everyone knows them. Tiffany's a good example too. They've got their little boxes of trademarked, their little pouches, the Tiffany teal, the color. They're getting everything that they possibly can that distinguishes their goods and services from others. But generally speaking, with any small business, we're talking about normally first cab off the rank, your business name. Because yeah, that's who you've kind of identified your goods and services. If you can get it, if it's not too, if it's not too descriptive, and sort of does what it says on the tin, like Sydney Legal Services, that's going to be an issue, Hunter Valley Family Lawyers might be a problem, because they IP Australia, it's exclusive rights and use over this to the exclusion of all others. So it's a really big thing to get if you can get it, and the more unique and less of those types of descriptive features or geographical sort of locations and some other sort of stuff, the less of that, the better, and the more chances you've got of getting a registered trademark.
Yeah, no, very interesting. We do have in the chat some input from Annie. So recent case, Adidas sued Payless for selling shoes with similar stripe designs. There you go.
I'll say that again. Adidas
sued Payless shoes for selling shoes with similar stripe designs.
That's and Adidas. Adidas and what's that great Aldi. Aldi does this all the time. They're very, very clever with their marketing of these products that look and feel, and they're just very, but they're now like it's now almost, comedic how far they push the envelope, kind of like how Ryanair is, unashamedly ripping off people for, oh, you didn't print out your ticket, so that's £50, the week. And then anyway, that's just one of those things that they stand tall on,
And MCO Beauty, if you've seen that one, I mean, their whole business model is just to rip off other brands, and unashamedly as well. So
yeah, I've noticed that's very common in the beauty industry as well. So because you can get, for example, the Charlotte Tilbury, something I use personally, the Charlotte Tilbury blush tube thingies that you squeeze. There's a lot of other brands now doing that, but selling it for like $10 instead of $50. Exact same design, even the coloring and the packaging, and it's all the same, which is quite interesting. And the quality is slightly, like, it's not that different, right? So I'd rather pay $10 than $40. Like, who's gonna know?
And there's some really famous famous cases of where businesses haven't done what they needed to do to protect that name and stop others, that they've basically been guilty of what they call laches, acquiescence. It's basically if you're acquiescing to the conduct if you don't do something about it within a reasonable amount of time, right? So Band-Aid is a good example of that. They didn't, I think they'd protected the name Band-Aid, but they hadn't prosecuted it enough, and they eventually couldn't rely on it as a badge of origin. So it became kind of like like one of those names that you're constantly, referring to as, for types of goods, like a sometimes, like a Kleenex, right? What are some other ones? Help me out here.
Gurney,
a gurney,
yeah.
A gurney. What else? There's all these like that where they're synonymous with, like, oh, that's that, that brand, because they came up with it first, right? But they obviously didn't do enough to protect it at the time, and then they lost the rights to then be able to prosecute it. And there's a number of these trademarks that have unfortunately fallen foul of that. That's just one part of intellectual property, right? But just coming back to that example before, a business might have been in business for a while, right? And they've come up with a really great product name, or a really great hashtag, or a really great something, product, that actually may be the first thing that they want to get, registered protection for, and then come back and do the rest later. So be practical about, that protection. Also, too, you can set things up for monitoring services as well too, and you can, I'm sure Hungry Hungry Jack's and McDonald's. We know that's another good example, like the Big Jack. Like they're constantly in court together, McDonald's and Hungry Jack's, because they can't help themselves. And I mean, it's good for business too, creating that sensation and the hype and the drama and the and the fight. It's sometimes it's just what they would potentially consider just a cost of doing business, right? But obviously we don't deal in those areas, and we want clients to stay away from that stuff as much as possible. So just making sure, like, there's a few things you can just do before you go and land on a business name, before you go and land on a logo, before you go and land on a tagline, before you start using it in the market and all sort of stuff. There's just run some stuff past us really quickly. We can check and make sure we do that. We do that for anyone coming through that just wants to get a little bit of advice first up. Hey, am I gonna get a letter from someone really, a big scary law firm, if I start using this? And before they go down the road of like spending all this money on graphic design and all this work from third parties to do this work, we had to unfortunately give clients some bad news once. And I spent maybe 20 grand on marketing, and we had to give them the bad news that there were probably 6 registered trademarks that would have been one of which we knew were very protective of their brand, like a global international company, and so we had to advise them to go back to the drawing board, and that was a really awkward conversation that they had to have with their branding agency, because they didn't just do some fairly quick and simple checks just to make sure that was all clear before they set their heart on it and go and register all the domains and label and all, branding and all the rest. So there was a lot of time, energy, and effort, and the 20 grand that they'd spent on the branding that they shouldn't have had to go down in the first place. And obviously that's and especially they were a startup. So when you're in that zone of that startup phase, any of these types of major setbacks can hit very hard. I think the smaller the business is, the greater it needs protection. Just like a baby cub. Can't just go sending it off into the wilderness and go hunt some some zebras, get kicked in the head. Like you just can't do that. So you really need to protect this stuff with small businesses, right from the outset. And just think of, and kind of just need to think about this as this is just part of the investment. It's part of the we're talking about risk management here. It's perhaps income producing as well, but we don't know what that will be. But it's just part of doing business, just like getting your legal structure right, your legal documents in order, and protecting those things. Like, these are things that you make these mistakes once, right? You don't protect a trademark and then you get involved in trademark infringement. I hear clients coming to us going, yep, that's the first thing we need to tick off. Don't have a shareholders agreement, you're in business with others and it all falls apart. First thing they say to me is, we need a shareholders agreement before we start this business. Employment contracts, you only make that mistake once. And they say, hey, we're employing this new person, need to get this sorted, or an independent contractor. Oh, been done over by a web developer. Guess what? Next time they engage a web developer, that's a mistake they don't make again. So like, we have to learn from each other's mistakes, and of course, unfortunately, mistakes are not something that people talk about a lot. So unfortunately, we have to really hunt for those things to find out, or pick the brains of people like me and even more experienced that have advised lots of businesses about those mistakes and find out how not to make them in the future. That's why you get that advice. Just like you pick your accountant's brain and make to see what you can do to make sure your financial success.
Yeah, and I think IP is actually one of the trickiest ones. As you said, one of the biggest mistakes, because you see a logo, you see a color, you find the perfect name that you like, and you don't think about anything else. You just go about and kind of before thinking, you make your branding, you go pay marketing agencies, you do all of that, and then you realize, oh, wait a second, like, yeah, I think it's a bit of emotion that plays into that as well. I think if you're
Yeah, people get really attached.
you fall in love with these colors and brand names
Yeah.
and all
Yep.
things that really suits your business. You kind of overlook that bit. And because it does seem to be complex, so people try to avoid kind of that aspect of things as well, I think. So
But like everything, you know, like sometimes most often the hardest way is the best way, right? And
yeah,
although you don't want to get paralysis by analysis, and everyone's encouraging people to, like, you know, just get started and get underway and, you know, and give things a crack and go for it. And as Australians are typically notorious for the, you know, she'll be right, mate. You know, I'll engage a lawyer if there's a problem. You know, that's unfortunately in business, it's just, you know, and like, look at the US and how cavalier and, you know, cowboy the US are, but they're damn sure that they have legal stuff sorted. You know, because they know that there's, you know, there's a high risk of getting sued in the US if you don't do this stuff right. And unfortunately, I think that's the way that we're moving in Australia. Sort of just generally speaking, we're moving more towards that, but not at a rapid pace. But still, like I said, you make these mistakes once, and people are, you know, their stitch in time saves 990, 900, 9,000, the whole bag. Like, you know, and measure twice, cut once. Just do things right, do it properly, do it right from the start, and then you can have at least the ability to say, I've done all I need to do. If I'm, you know, the owner of the business or the director, I'm putting my director's hat on and doing what's in the best interest of the business at all times, and that is getting advice from people who know what they are doing, and make sure that I, you know, follow their advice, because they, you know, they know what they're talking about, and do what they say, and do the right thing, and make sure things are done in succession and in order of priority. And obviously you got to, you know, practically and financially, you work that into your matrix, but don't go and do it when there's a problem. Like, do it before there's a problem, because I can tell you from personal experience, you know, the prevention is way cheaper than the cure. And sometimes, you know, some cures can't be done. So that's the kind of message that you want to be sort of receiving from this perspective. And IP is just no different, right? It's just it's part of your business, and sometimes it can be, you know, really, really important. And there's this huge debate that sort of rages all the time on Facebook groups. They're saying, oh, you know, NDAs aren't worth the paper they're printed on, or enforcement of restraint of trade clauses, it's impossible, and all of that is just BS. Because at the end of the day, if you've got this stuff in writing, one, it sends a clear message that you're serious about it. Two, it gives you the legal rights to enforce it where you would otherwise not have. Three, if you like, if I'm on the if my client is on the receiving end of a breach of confidentiality, or breach of confidentiality agreement, or a breach of a restraint of trade clause, where that restraint is reasonable and with cascading clauses and all this sort of stuff that, you know, that makes it a legitimate interest of the business to be protected, it's a very different conversation to, like, oh, this document's silent about it, or vague, unambiguous, not you know, contradictory or whatever. The conversation goes in completely different directions to, hey, this is really well drafted. Hey, they've got a registered trademark over these goods and services. Hey, they've taken those steps to protect this. Like, we need to get you out of this ASAP before you get landed in court. To the alternate conversation, which is, hey, they haven't done anything about this. You know, you're on different grounds here. Like, we're having a completely different conversation. That's if they're getting the legal advice.
Excellent.
just from a practical perspective, this is what and we, it's all about this practical, reality, right? And the enforcement.
Yeah. Excellent.
And there's lots of iconic IP stories. We could be here for hours.
Discuss. Yeah, no, those are excellent. Thank you. So we've discussed a lot today. Let's have the last 5 minutes for questions. So please feel free to ask any questions in the Q&A via the chat, and we'll be happy to answer them. So we'll open it up for questions for the next 5 minutes. And I guess whilst we do that, please let us know if you would like to hear more about IP and branding after the webinar. That would be lovely.
While those questions are coming through as well too, Ava, one thing that I forgot to mention was when, everyone knows that basically if you've set up a business so that it can be sold, or a saleable business, then you've got a really valuable business, right? And it's usually run really, really well. And a lot of businesses nowadays are doing that, even if they've got no intention of selling. They're going through that process what others are doing to make the business less reliant on the owner of the business, and making sure it ticks all these boxes that a VC or a prospective purchaser of a business will have a tick box list of things, and that list includes, hey, has the business registered all their intellectual property? Have they registered, what's their intellectual property? Where is it currently held? Does it need to be transferred? Is it held in the right place? If it is capable of registration, has it been registered, and for how long? And is it over the right goods and services? Because venture capitalists know when they've gone and bought businesses and then there's been a trademark infringement and a piece of litigation in the federal court, this is stuff that they just don't want to get anywhere near, because they have made that mistake once, right? And they will literally look over businesses unless they have got all this stuff sorted. And intellectual property, I know we're trying to focus on that today. These things are part of that checklist. Like you've seen on Shark Tank and Dragon's Den and all the rest, right? They're like, where's the IP? Have you got it registered? Oh, have you got a patent? Show me the patent. I want to make sure that it covers you for what you are doing. They actually look at the patent. They look at this stuff and they go, before I make an offer to you, I want to make sure you've done all this first. So, and there's lots of times where businesses have wanted to sell, or they've had to sell in a difficult time or in a particular market, and they because it takes 6, 7, 8 months to get a trademark registered, right? That means finally IP Australia has granted them the exclusive ownership after going through a whole bunch of hoops with the examination, the acceptance, and then a period of 2 months for other traders to object to the trademark if they don't think that if they think they're a better owner of the trademark than them, or that this company shouldn't be granted, or this person, whatever, this business shouldn't be granted that trademark. 2 months of that opposition process, and so if someone's come along and said, hey, I want to buy the business, give us a look under the hood, they look at all the financials, look at everything else, and they go, oh, you haven't got registered trademarks. Oh, well, come back when you've got them registered. By which time 8 months is gone, they've moved on and bought some other business. There's no money left to buy yours. So we know that this is it's valuable intellectual property, and it's best to do it now as soon as possible, so that you've got that length of time, so that there's no deal breakers if it comes time to selling the business, or if it comes time that you want to license something or sell part of the business, right? If that's a part of the business that you want to sell off separately, is it all set up properly for sale? This stuff takes time, so you're better off just doing it now.
Yeah.
We don't have any questions in the question box, but I'll just read one out to you. It was from Adriano, and he has said, love how passionate you are about IP, Ian. So that's definitely a nice one to see.
Appreciate it. Thank
Annie, Yeah, Annie has thanked us. Informative lunchtime webinar session, engaging and valuable. And it's given her some valuable thoughts about her career path as a law graduate. So that's a nice one as well.
Yeah, when I went through uni, I remember I did, apart from as many subjects in marketing as I could, to not have to do econometrics and advanced statistics.
Good choice.
Yeah.
Great choice.
Yeah, apart from that, in my legal studies, I did in my electives IP and IT law, and unfortunately, 20 years ago, there wasn't a lot of this type of work out there unless you were working for, large IP firms, which weren't necessarily law firms and weren't really interested in hiring lawyers. They were more interested in hiring trademark attorneys and patent attorneys. So there really wasn't a lot of this work out there 20 years ago. So, and then it's very easy to get pigeonholed into particular areas. I got pigeonholed into litigation, and it was very difficult to convince a recruiter to put me in a role anything other than litigation, even after just 2 years of litigation. So my advice to you is, if you really want to get into a particular area, just go straight at it. Don't jump into something else that you may not like. I'm grateful for the litigation experience that I've got, because it's great, because you've got a really great eye on the front end sort of stuff and knowing when things go wrong. If you're interested in IP law, there's no better time like the present to get into intellectual property, because it's really starting to ramp up now, and I think it's just going to continue. In this digital age, as you're saying, Ava, it's just going to get more and more prolific. There's going to be more and more toes trodden on as things get narrower. Like, it's very difficult to get a trademark now on the US register. It's not easy. It's not easy at all.
Takes a long time as well, doesn't it?
And having to go through lots of different, submissions or evidence, or trying to obtain consents from third parties if that's the only way through. There's obviously a minefield and lots of stuff we can talk about. But maybe because I know I've spoken a lot in this webinar, is there any matters that sort of have arisen from a marketing perspective?
Yeah, I think the key things in terms of a marketing perspective is building brand equity and trust and credibility, and having that kind of long-term vision for your brand. Because the one thing I'll wrap it up and I'll say is, if you don't actually have a brand, then you don't actually have a business. And IP plays a massive role in helping you establish a brand that's reputable, trustable, and has longevity. So I think getting that IP started from the beginning, and before you think about your marketing, before you think about your logo, etc., make sure that you do really have everything Ian discussed in place, to make sure that you get it right from the start, because you want to be proactive and rather than reactive and have to find yourself buried in high costs and litigations and things like that.
This is the DNA, right? This is the DNA of your business.
Of your business.
It's how you communicate.
Yeah.
Your marketing, your branding packs, your messaging, your tone of voice, your language, it should all be sort of coming through and consistent and congruent on all the platforms, making sure that it's really, really consistent, right? And that's why, like law firms, I couldn't work it out why Gaydon's had a style guide, right? And I was like, oh gosh, they've been telling us how to write. Amazing. But now I sort of understand the importance of that it's all about consistency, and from a client's perspective, when a client sees things, it's all in the same language, it's in the same same wording, same breath, same message, so that it's not contradictory. Because when clients see contradictory stuff, they get confused about the brand. What are these guys about? What do they stand for? What are their principles? What's their value? Why are they unique? Why are they different? And perhaps the great thing about a law firm now, and that's obviously changed a lot from a marketing perspective from 20 years ago when I started, when I first started practice. But we are really seen, unfortunately, as a homogenous group, where clients just sort of think, hey, you're a lawyer, don't you just come out of the factory just sort of stamped and like that Monty Python thing where they get stamped and then everyone comes out looking exactly the same on a conveyor belt, but anyone will be able to tell you that there are lawyers and then there are lawyers and there are law firms. Some law firms do things very differently from others, but how do they communicate that difference? I think people are in a very grey landscape. I often joke about this to service providers when they talk to us. Like if we put our little pinky finger out, it looks like we're putting our whole arm out, because that's how different you can be in a fairly grey environment. And I think that traditionally we were encouraged as lawyers to kind of conform, to look the same, talk the same, act the same. But I think in reality, what clients really want is someone is a lawyer that's personable and relatable and speaks their language and doesn't speak down to them or at them or lecture them or or speak a different language, and we're getting rid of this legalese and big words that people don't know, and save that for the court, save that for the other side. Like, fill your boots if you want to write to the enemy, in a legal matter with as much Latin as you possibly can fit on a page. Like, that's within reason. But like when you're talking to clients, when you're writing to clients, when you're conversing with clients, when you're providing advice to clients, they want to be spoken to in a language that they understand. So and that's that can be that, if that's alone your point of difference,
your personal IP.
that's it. And
your personal IP.
yeah, absolutely.
We've just got one more question.
Yeah.
Before we wrap up. So we've got from Mariam, how long does it take in the US, I guess, to have an IP registered? Would you know?
How long is a piece of string? Yeah. It's if you can get everything clear and all through, I think it's running at about the same as in Australia, perhaps just a little bit longer. And also too, it depends if there are issues having a local representative, and we've got a few. We're collecting more and more in each jurisdiction as we're doing more work now. Having someone already involved on the matter that we can run past quickly and just sort of say, hey, what do you think of the prospects of this is? And they'll come back and give at least some realistic prospects before you file the mark, so that then if there is an issue with the mark after you filed it, you just go back to that same person and go, hey, we gave it a shot, now there's a problem, can you help us? And they've already got a head start onto it, so there's no sort of delay from that perspective in getting what they need organized to try and overcome that. So yeah, definitely network of people that are trusted certainly helps, and we're collecting those. The one thing I should say, just to leave on with trademarks, is the real thrust of it is, if you've got a registered trademark with IP Australia, it means you don't have to rely on reputation in the market, and reputation in the market is actually more difficult than you think to prove. You have to be of a certain size, and sometimes spending so much money on marketing, have really good brand recognition in the market before the court will say yes, you've got that reputation. But with the power of a registered trademarks is you can rely on the Trademarks Act, which means that you don't have to prove reputation to sue for a trademark infringement. You still put that stuff in as well, like misleading and deceptive conduct and this old tort of passing off. But if it's a direct trademark infringement, because you've got a registered trademark, this is what it's all about. And when the court looks at an offender of a registered trade, that's offending a registered trademark, and the business that's prosecuting it has taken the steps to register it. It hasn't been opposed during that opposition period, and they've got a registered trademark. As long as they were first to use it, like as long as they weren't registering that trademark in bad faith or otherwise, then usually the gavel comes down on the other person's head, because they were there first and they've registered a trademark over those goods and services. So that's what it's all about, right? Just like having terms and conditions. No point having pretty looking terms and conditions which are unenforceable, and when it comes time to be before a court or a tribunal, unfortunately for us small businesses and small law firms, especially as law firms, my goodness, the bar is even raised higher. You really have to jump super high before a tribunal or a court finds in your favor as a law firm. And we can't even rely on general ordinary sort of consumer protections where we're lawyers. We should read every document. Oh, we're lawyers, you should have read the terms. What's your excuse? It's not that you can't read, is it? No. The bar is just so much higher. So I think every lawyer kind of knows that. You come before a tribunal or a court as a lawyer, you're not looked on favorably. You have you got to jump. So you got to jump much higher than the ordinary human being.
Oh, wonderful. All right, thank you. That was a great question to wrap it up. I think we're way over time, but so much to discuss. I don't think this is something you can cover in an hour. So for that reason, I've put on our contact details here as well. So if you have any other questions or would like to reach out to Ian or myself, please feel free to send us an email or give us a call. But thank you everybody for joining.
And if you want to talk to a non-lawyer, Bree's contact details are there.
As well.
Yeah, I've popped my contact details in the Q&A box as well. If anyone had questions that they didn't want to write there publicly, they're more than welcome to contact me directly.
And the phone number there is Progressive Legal Firm phone number, so please feel free to contact that as well. Yes, so thanks Ian, thank you Bree.
Thanks Ava, that's great. I'm looking forward to doing the next one.
Looking forward to it.
I'll find some more cool examples to show you. Thanks everyone.